Welcome to the Main Street Counsel podcast.
Welcome back to the Main Street Counsel podcast with Jasmin Hurley. Jasmin Hurley is the founder of JH Legal and a transactional business attorney who brings big law experience to Main Street businesses. She helps owners make smart legal decisions before things feel urgent, explaining complex issues in plain English without panic or legalese. I'm Evan Mack, and today we're talking about online contracts, specifically when something from the internet creates more problems than it solves. Miss Jasmin, my dear, welcome back.
Thank you, Evan.
Amazing. So Jasmin, what's the core problem with using a contract exactly as you find it, whether from an internet search or maybe an AI tool?
Yeah, so this is becoming a big thing, right? A lot of founders are, you don't have a lot of money when you first starting your business. So when you were trying to get those contracts in place, you're going to the internet. The internet is a wonderful and fantastic resource for a lot of things. So a lot of people are able to find those templates on the internet, or they're using generative AI like ChatGPT or Claude to find some of these documents to create them from scratch. The thing that becomes the issue from these documents are they're not exactly for your particular situation, your particular business. They may have a lot of what you need in those documents, but it's about what's not in there sometimes, right? They can actually work against you if they don't have what you need in that agreement, in that contract, to either mitigate your risk, to shift liability where it needs to be shifted to the other party, or even some of the more basic things in a particular situation. I've seen some generative AI contracts that have come out and you're like, okay, it doesn't even say how long the duration for this is or how you get paid, right? These are some pretty basic things that should be in every contract, right? How do you get paid? So being able to understand those, they're great starting points, but they should never ever be the end all be all final point of where you're going for these. And another thing is leverage, right? Some of these things can work against you, and they may be giving the other party, more leverage over you than what you intended to hand over.
So why do these contracts look so professional and thorough on the surface, even when they're completely wrong for the business, that is using them?
Yeah, well, because they are, most of them, legal language and structure, they create this illusion of authority, right? Just because you throw whereas, here and after, therefore into an agreement vis-a-vis, those types of language does not make it as official. It doesn't mean that it is actually doing what it's supposed to do, right? That's the whole purpose of a contract. That's the whole purpose of an agreement. It's governing the relationship between two or more parties for a particular purpose. So even if it has all of those words in there and looks official, if it's not actually meeting the purpose of having that contract, the purpose of the contract and the intent, then it's just a bunch of words strung together. A couple years back, there was a big drive for people to start writing, lawyers to start writing documents in plain English. So instead of having some of this more elevated formal language, the whereas and the heretofores, it was, a push for, hey, this is what this is about. This is the purpose of this agreement. I agree to do this. You agree to do this. A document that says that, as long as it is getting the key points and key terms down on how to govern that relationship for that particular purpose, and everyone understands what they're supposed to do when someone is not doing what they're supposed to do, and when they are supposed to provide notice for termination, if somebody's breaching the contract, then it's meeting the intent. So even if it doesn't have the fancy legal language, it can still meet the intent and the need. It also goes back to, again, spotting what's missing. And I'll admit, I will use generative AI as a first draft pass, especially if I don't have a template for something, but I generally know what I'm looking for in a template. I may use generative AI as the first draft, but then I also then have to go back in and say, okay, here's what's missing. I know that it's missing notice. I know that it's missing dispute resolution provisions. I know that I'm missing some of the more basic, termination notice and termination provisions. So being able to spot what's missing is really important, because that's, again, where gaps start to form and where your contract becomes kind of useless.
So AI tools, like ChatGPT, will actually generate that full contract if you ask. What's the danger of treating that output as finished, a usable document?
Yeah, it will give you. So one of the things that I notice, and some of the things that I'm using are specifically legal, generative AI used in a specific legal realm, these products. It will still give me, if there's any type of a legal statute or a case, you need to double check that. Sometimes it's not right. Sometimes it points you to the wrong thing. It will get you, and I was just using it this morning, and even the legal AI, platform was like, okay, this is the law that applies. I read the law. The law doesn't apply to that particular situation, right? So you always want to make sure that you're avoiding those hallucinations, and you're double checking any very specific references, right? Again, understanding what's missing, what might not be there. And this is one of the dangers. Don't want to go too far. I feel like there's a whole separate podcast about the dangers of generative AI in the legal sense, right? We just had a court case where, come out where, a person was taking what their lawyer had created for them and then feeding it into generative AI, and then that was deemed discoverable. So basically, attorney-client privilege was destroyed because he was feeding the attorney product into generative AI. Don't do that. It's a whole completely separate podcast on how AI should not be your lawyer. But it's an incredible tool, but it should be used wisely. There are some nuances to some of these contracts, and if you're missing some of those nuances, the product that's spit out by generative AI, or even grabbing a template off of the internet, a pre-made template off the internet, you're going to miss some of those nuances because you're not looking for them, right?
So which type of contracts tend to cause the most legal trouble when they're pulled from the internet or generated without, customization?
Yeah, non-competes and NDAs. That's one big one where a lot of folks don't realize, what that means. They may say, I want an NDA that only protects me. That's fantastic, but what does that mean in the relationship? If you are both exchanging information, a mutual NDA or mutual NDA might, or confidentiality might make more sense. Understanding what you actually have listed as confidential information, right? For some folks, they have this huge listing that may be put out, or a more generic, broad listing. But sometimes that broad listing does not specifically call out certain things that are happening. So if tech products are really, really big. If there's some particular software, we want to make sure that that's included in this really broad definition. And if we need to get a little bit more specific so we know that that's not going to fall through the gaps, then that's something that I like to pay attention to in, looking at NDAs. Independent contractor agreements are another source of concern, because you can pull a contractor agreement, but again, when you're working with an independent contractor, it's like, whether they themselves are a business or they themselves are a freelancer, you have to make sure that you are contracting specifically with them for whatever they are doing for you, as if they were a business. That also means that you need to make sure that your intellectual property is protected. This is a conversation I have pretty frequently with folks that are like, oh, here's my contractor agreement. I put it together and I was like, okay, cool. They're creating something for you. Do you own it, or do they own it at the end of this project? Oftentimes they're like, oh, I own it. And I'm like, well, according to case law, they automatically own it unless they have specifically set out in that contract that they are passing those rights and that ownership on to you. an independent contractor is different from an employee, right? If an employee creates something in the confines of their employment under law, it belongs to that employer. If I, as a contractor, are creating something for you, and at the end of the day, this comes up a lot with photographers, right? Folks are like, oh, well, they're using my pictures, they're using my photos. Yeah, they still hold the rights to the photos under the terms and the agreements. They can use it for marketing, right? You were just getting a license to be able to use your photos for your life that they took of you. So a lot of folks don't realize when they are doing those independent contractor agreements that is something that pops up pretty frequently. Non-competes. People will pull non-compete agreements, and usually those are embedded in either employment agreements or independent contractor agreements, not realizing that each state has some different nuances for independent contractor agreement, or not independent, non-compete agreements, and what is allowed and who is allowed to have a non-compete in place. In Ohio specifically, your non-compete, when you are talking about an employee, it has to have certain restrictions on it. You can't just say, hey, employee, you're not allowed to compete at all, go to a competitor at all. You have to be very specific when it comes to geography and when it comes to time frame. Now, if it's a business in a mergers and acquisitions context, those rules are a little bit looser. So understanding those nuances and understanding the laws behind it, if you don't understand it and you're just pulling something off the internet, especially something that is not particular to your state, can cause a lot of issues. And then the last one, service agreements. I see this a lot. Some folks who are providing certain services, not understanding indemnification and liability, not even having it in the agreement is a big issue. But then not understanding how to limit the liability, what type of liability you as a service provider, depending on the type of service, have in that particular in your particular industry, and not making sure that you're either shifting that liability, disclaiming that liability, or at least limiting it in your scope of work.
So, Ms. Jasmin, Ohio business owners, are using contracts written for businesses in different states all the time. How does that state law kind of actually change whether the contract holds up?
Yeah. So if kind of going back to I'll use the non-compete as a great example, right? A non-compete agreement that is too broad, right? So something that is used in another state and violates Ohio, well, guess what? Now your whole non-compete is null and void, right? Did not follow that particular law for this particular state. So understanding the references, understanding the laws and how those play into the last thing you want is to put a contract in place that is completely unenforceable. You've just wasted your time, you've wasted your client, your vendor, your customer's time, and now you have an unenforceable agreement, and you have egg on your face. So being able to understand how each state's laws in particular situations affect what you can and cannot put into your agreements is really important. So as you're pulling contracts off the internet, as you're pulling templates, really paying attention to the state that it says. So there's this I'm going to say 99.9% of all agreement templates that you're pulling off the internet, right? It'll say governing law, and it'll say state of Delaware, state of California, state of Ohio, governing law. The jurisdiction for this is this type of court in this state. Paying attention to that and understanding that particular template may not be the best for you because it's California law. California law tends to be a little bit more stringent and have a lot more protections for their employees for certain types of situations. They require different notifications and notices. We don't have a lot of those things in Ohio, but we have other types of laws and requirements that we need to follow in our contracts. And being mindful of that and not understanding that can become a big gap in your agreements.
What are the red flags inside a contract that tell you it's never actually written for a business like yours?
So when they tend to talk about things that the business doesn't actually do, right? You can tell when somebody has just pulled something and they haven't read the agreement, because there are, it'll say the purpose is, and then the purpose of the contract is completely different from what is actually being, the purpose of that particular agreement and the focus of that particular agreement. Liability, right? Someone may be assuming more liability than they have to in a particular situation, or they're not disclaiming enough liability in a particular situation. Those are scenarios and red flags when I see agreements that may have been pulled off of the internet. There are other items like maybe payment disputes, termination terms, those, the terms of the agreement. The term of the agreement may be, for a lengthy period of time, and that doesn't make any sense for that particular engagement. So, folks not going through and really paying attention to, that template. IP ownership is another one where, especially in the context of independent contractors, when we haven't defined who owns the intellectual property, it goes into those default rules, right? The default case law that the intellectual property belongs to that independent contractor in that situation. I will say that, if that contract is not written for that specific business model and it does go into a dispute, right? So it goes into court, there's a dispute around it. If the contract is silent or ambiguous about certain things, depending on the court, they may either completely strike if they have the ability to blue line. So that means, they put in play, the court puts in place the best possible scenario for both parties, or they may completely invalidate that particular agreement. If you are the person where the agreement favored you, but it was considered ambiguous or void, if you were due payment under that agreement, you're kind of left in the lurch.
And finally, for the business owner who needs to move fast and sign a contract tomorrow, what's the minimum they should do to protect themselves when they don't have time for a full contract review?
Yeah. Even having, it's quite often that I have folks who say like, hey, I put this together, or I pulled this. Can you review it? More often than not, yeah, I can review it. I can very quickly, see what's missing, right? Because I've done enough of this now over the last 10 or so years. I know, okay, we're missing limitation liability, we're missing indemnification, we're missing, these types of provisions that protect. Also understanding the parties and understanding the leverage. Leverage is big. A lot of the documents that you will find on the internet tend to be from larger organizations that may have public documents out there. So they may be contracting with smaller groups or smaller folks, right? They favor those larger organizations. So if you're trying to partner with an Amazon, you're trying to partner with a Walmart for sales of products and things like that, those terms are going to favor them. Not understanding how those favor them or trying to then repurpose, that may not be something that works for you. You may want something that is mutually favorable to both of the parties. So having someone take a look at it, right? Nothing says that you can't do the first pass. If it's a hot garbage mess, I will then say to my clients, hey, I've got a template for this. It's already 100%. Or it's already like 95%. I just need to add your terms into it. Are you okay? Because it's going to cost you way too much money for me to review all of this. If you're okay with it, I'm happy to go in, put this into the template that I have that's been vetted, that I've worked with, that I know works, and then get it to you, right? And that's the glory of having a relationship with an attorney, or at least having an attorney to turn to and say, hey, I put this together. Is this okay? What are the issues? What are the gaps?
Amazing. Ms. Jasmin, thank you for your time.
Yeah, thank you.
All right. That's it for today's episode of the Main Street Counsel podcast. To learn more about Jasmin Hurley and how she helps Main Street businesses create contracts that actually fit their operations, visit jhlegalohio.com. Thanks for listening, and don't forget to leave a review and subscribe to the show so you do not miss the next episode. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.